Sarah Young and I'm with my colleague Samantha Hirst. We're both solicitors who specialise in will disputes with Ridley and Hall. Sam, you brought a really interesting case to me, didn't you, a few weeks ago that you'd come across called Ninian and Ninian, and it highlighted a rule that I'd kind of forgotten about really, that seems to have an incredibly unfair effect on the family of someone who's committed suicide. Tell me a bit, just remind everyone about, or there'll be lots of people who don't know anything about this case at all, on assisted dying. Just remind us of the background of what happened.
So this is a really tragic case. What happened was Mr. and Mrs. Ninian, husband and wife. Mr. Ninian was unfortunately diagnosed with a really nasty disease called PSP. And it's a degenerative disease which affects brain cells, and what happens is that it would eventually have affected his swallowing, his movement. So it took him 3 years after the diagnosis to decide that he wanted to end his life by way of assisted suicide with Dignitas in Switzerland.
That's because it's not legal to commit suicide in this country, isn't it?
Yeah,
It's
absolutely.
still a criminal offence.
It is. So he arranged it. At the time he started arranging it and decided it, Mrs. Ninian wasn't aware of his decision. When the decision, he told his wife. His wife was very reluctant, obviously, and naturally she wanted her husband to be around as long as possible. But she couldn't, she couldn't persuade him. So she decided, well, I love my husband and I want to carry out his wishes with him. So she helped him with all the paperwork.
And there was a lot, wasn't there? It was interesting to me on reading the case that he did as much preparation as he could to leave his affairs in order. I mean, he took legal advice,
yes,
he took medical advice.
Yes, he saw solicitors, drafted up his will. He drafted up his will, I think, a couple of weeks before he went to Dignitas, but took full advice on what he was doing by his solicitors. Yeah. And Mrs. Ninian, was involved in those decisions as well. Yeah. So he went to Dignitas. She went with him, and then when she came back to England, she was unfairly, I think is fair to say, faced with both a criminal conviction, and it was whether or not, because Mr. Ninian did a will, left everything to his wife, Mrs. Ninian, whether or not she should benefit from his estate.
And I think they decided, didn't they, the CPS, not to prosecute in the end.
Yes.
So she wasn't actually charged with any offence under the Suicide Act.
That's true.
But what we're concerned with, and what the court case was about, was the application of something called the forfeiture rule.
Yes.
So to just explain again, what's the forfeiture rule about? What does it say?
So with the forfeiture rule, what it says is that an individual cannot benefit from someone else's death if they have unlawfully aided, abetted or procured the death. So with that in mind, it was that Mrs. Ninian was not going to inherit any of her husband's estate because she'd gone with him to Dignitas and been involved in some of those decisions. Yeah,
and effectively assisted in the suicide. And she didn't deny that, did she? She didn't say that's not true, I didn't do that.
No, she was very open about it.
And what's really startling for me is that she comes back and she must have been absolutely devastated by having lost her husband. They both thought that they'd done everything that they possibly could in order to be open and clear with the police and the authorities, and even so she had to bring a court case for relief against forfeiture so that she could inherit his estate.
Yes.
And so all of the legal arguments had to be put. Goodness knows how much money it must have cost her to bring that case in the High Court and all the evidence. And then the finding was positive, wasn't it?
It was. The finding was that she was able to benefit entirely from her husband's estate, and the court took into consideration, various circumstances of the case, and I think each case would be looked at on its own merit and its own circumstances, but some of the things that the court took into consideration, there were 6 factors, but some of the main ones were that Mr Ninian had reached a voluntary, clear and settled and informed decision to commit suicide, which I think is probably the most important. And Mrs Ninian was wholly motivated by compassion. There was no malice in it. You know, she did it because she loved her husband. That was the outcome.
So it's the right decision, isn't it? But I think what we both feel quite strongly about is that the law that we're looking at, that in this country is the Suicide Act 1961, and the Forfeiture Act is 1982, but both of these laws are pretty much out of date, I think, and out of step with current thinking about depression, suicide, end of life decisions. I mean, there's a huge debate ongoing, I think, isn't there, about the pros and cons of euthanasia, and I suppose that will probably carry on for some time. And you know, we might have our own personal views about that, but I think we both feel that it seems very wrong that a widow or a widower in the situation that Mrs Ninian found herself in should have to make an application to court to inherit when that was clearly his intention and desire.
And I don't know how you feel about this, but I can see more cases like this going through the courts, given that we're all living longer and with medical technology progressing. And people have just access to more information these days. It's only natural to see that more of these cases will be going through the courts.
I think that's right, and I think that we need to be looking at, or the government needs to be looking at, changing the Forfeiture Act to be a little bit more compassionate to people in this situation.
I agree.
So this is an issue we wanted to highlight. It's not going to happen that often in society, but we both feel that it's something that people need to be aware of and needs to be debated and ought to be addressed. So we are Sarah Young and
Samantha Hirst,
and we are Ridley and Hall. Thank you for listening.
Thank you.